connected.
Ready to go? All right, well, I want to welcome everybody today to Pators Perspective. And my name is Dr. Andy Woods. I'm the pastor teacher here at Sugar Land Bible Church. And with me is a guest today who opted to fill in at the last minute, Tomalea Bench, who is a member of Sugar Land Bible Church. And she also has a real heart for politics and, getting Christians involved in politics. And so she studies a lot about politics and knows a lot about it. And so she's going to be sitting in. Dr. Jim McGowan is sick today, so you can pray for him. And, the last couple of episodes we did it on the borders, what the Bible has to say about borders. And sort of related to this whole subject is our president issued an executive order, to protect our borders. The executive branch of government enforces the law, right? Mm-hmm. So he gets into office. He actually, to his credit, does what he says he would do, which is kind of rare for politicians these days. And he issues an executive order to protect our borders. He enforces existing law, which is what the president's supposed to do, right? And lo and behold, a federal district court judge on the West Coast, the left coast as I like to call it, comes in and renders that unconstitutional. Mm-hmm. So then it goes up to the circuit court, which is the appellate court, and that court upholds what the district court did and renders it unconstitutional. And, when I see things going on like this, I would put it this way. It tests my sanctification to the breaking point. I get so upset with this. And the reason I get upset with it is because it's part of a long pattern. And most people don't see the pattern. But this happens over and over and over again, where the people want something, the people vote for something. I mean, if there's anything clear about the last election cycle, people voted for Donald Trump because of his immigration views. And people liked the idea that he was going to build a wall around the United States. And that's what the people want. Well, here comes a guy, he gets into power, he does just that, and some judge puts handcuffs on him. And so kind of the title of this, and we may have to carry this over into next week, is Our Tyrannical Judiciary and How to Fix It. And I actually did a blog piece on this. If people access my blog, The Word on Politics, and my name, they'll find this article. But Tomalea, this is like a long, long pattern. And I have some information here from historian William Federer, who quotes all of these recent scenarios where this has happened over and over again, not just about immigration, but about abortion, about prayer in public schools, about this, about that. And can you read through that list just to kind of acclimate us to get people to see this long-standing pattern that's going on?
Yes. Arizona voted English as their official language, but federal judges overruled. Ninth Circuit, Proposition 106, March 3, 1997. Arkansas passed term limits for politicians, but federal judges overruled. Supreme Court, term limits versus Thornton, May 22, 1995.
You could probably leave out the court. You could just read the first part of it,
Okay, Californians voted to stop state-funded taxpayer services to illegal aliens, but federal judges overruled. This was Prop 187. Mm-hmm. November 20th of 1995.
From my native state of California.
Colorado citizens voted not to give special rights to homosexuals, but federal judges overruled. This was Romer v. Evans in 1992. Missouri voters defeated a tax increase, but federal judges overruled. Eighth Circuit, Missouri versus Jenkins, April 18, 1990. Missouri citizens limited contributions to state candidates, but a federal judge overruled. Eighth Circuit, Shrink Pack versus Nixon, January 24, 2000. Missouri passed a woman's right to know. Governor Bob Holden vetoed it. Legislators overrode his veto, but a federal judge overruled. This was District Judge Scott Wright, September 11, 2000. Nebraska citizens passed a marriage amendment with 70% of the vote, but a federal judge overruled. U.S. District Judge Joseph Battalion, May 12, 2005. New York citizens voted against physician-assisted suicide, but federal judges overruled. Second Circuit, April 2, 1996. Washington citizens voted against physician-assisted suicide, but federal judges overruled. Ninth Circuit, March 6, 1996. Washington passed term limits for politicians, but federal judges overruled. That was Term Limits versus Thornton, May 22, 1995. Missouri's legislators passed a ban on partial birth abortion September 5, 1999. Democrat Governor Mel Carnahan vetoed it. In a historic session, 15,000 citizens knelt in prayer around the state capitol as the legislature overrode his veto. Days later, federal district judge Scott Wright suspended the law, and 5 years later, it is still in limbo. For years, a bill to ban partial birth abortion worked its way through the U.S. Congress, being signed by the President November 5, 2003. The next day, a federal judge suspended the law. In fact, 31 states passed bans on partial birth abortion only to have unelected federal judges suspend them. 34 states chose not to set up exchanges to administer Obamacare, but the Supreme Court decided in King versus Burwell, June 25, 2015, that the federal government could overrule the will of the states.
So you see a pattern here. I mean, it is so frustrating to look at this list. The people vote over and over again for something, whether it's against physician-assisted suicide, greater restrictions on abortion, and some judge comes in and says, no. And so the latest chapter, in this whole nightmare is the Trump executive order to, and I thought his executive order was sort of mild. I didn't think it was that big a deal. It was a temporary ban on 7 countries. Actually, Syria is more of a permanent ban, but the remaining 6, it's temporary, just to get vetting, procedures in place. Because a lot of these countries don't have a governing structure where these people are coming from. So they're not vetting them on their end. So it was pretty reasonable. And former presidents have done things like this, like Jimmy Carter. So once again, a federal judge says, no, you can't do that. And then it goes up to the circuit court. No, you can't do that. And in all of these cases, what you discover is there's zero textual basis for these decisions. So it's sort of this mindset where the judge's political philosophy is shutting down the will of the people over and over again. And when you bring up to these federal court jurists that they don't have any textual basis for what they're doing, what they say is, well, you see, you haven't gone to law school. You haven't graduated from the Ivy League institutions like we have. So we have this kind of secret knowledge that you don't have. And, in Christianity, we talk a lot about the early Gnostics that felt they had this kind of secret knowledge. Mm-hmm. And that's how I feel with these judges. And if you have that quote from Justice Scalia, who sadly passed away recently, he is greatly missed, but look at what he says here in one of his cases. That'd be quote number 2.
His quote is, "What secret knowledge, one must wonder, is breathed into lawyers when they become members of this court, that enables them to discern that a practice which the text of the Constitution does not clearly prescribe, and which our people have regarded as constitutional for 200 years, is in fact unconstitutional. Day by day, case by case, the court, is busy designing a constitution for a country I do not recognize."
And I love this quote because he says here, what secret knowledge is breathed into people. I mean, it's astounding the secret knowledge they come up with. Because your average Mr. and Mrs. America reads the Constitution, Wasn't the Constitution written for all of us? And they don't see the basis for all of these crazy rulings. And it's insanity what's going on. And one of the things that's frustrating about it is these judges are tenured for life at the federal level. So if I get upset, I can't vote against them in the next election cycle. So, I'm sort of stuck with what they have given us. So let's think about this for a minute. When one branch of government can overthrow the will of the people over and over again, based on nothing in the text of the Constitution but what comes out of their own mind, and I have no recourse against them through the ballot box, are we really living in a free country, or a free public? And the term that I like for this is what I would call soft tyranny. It's a soft form of tyranny. Mm-hmm. And jump in if you have any thoughts on it. I kind of analogize it to an abused spouse or battered, I think it's called battered wife syndrome, battered spouse syndrome, where, sometimes it's the woman that abuses the man, but usually it's the other way around. It's the man that abuses the woman. And she's being abused either verbally or physically. And the abuse becomes so frequent that she thinks it's normal. And she has an opportunity to leave, but is too scared or doesn't know how to leave. That's sort of the situation that we're in, I think, as Americans today, with the judicial branch of government. We're so used to our will being thwarted that we think it's normal. So we're kind of in the position of this abused spouse. And
we've come to accept campaign promises that they will be broken. Everyone says, "Oh, well, that was just said in the campaign." Would we do the same if we walked into a storefront and bought something?
Yeah. Yeah, and this came out a lot during the last campaign because people said, why doesn't the president keep this promise or that promise? And some of his staff actually said, well, he just said that in the campaign. Well, I thought I voted for somebody based on what they promised me. So when the politicians are not going back on their word and they actually try to do what they say, another branch of government comes in and tries to unseat what the people want. And people say, well, come on, Pastor, why are you talking about political issues? Why don't you get back to the Bible? Well, let's think about this for a minute. I counsel people that have had abortions. So what laws we do or do not have affects me and the kind of counseling I have to do. I'm an evangelist. I want to spread the gospel wherever I can, but I've got some federal judge telling me, don't teach it in the public schools, don't post the 10 Commandments here, take your thinking and beat it back, to the four walls of the church. I mean, doesn't that become a Christian issue? Isn't that an issue that affects me and my desire to propagate Christianity, in this country? So I don't look at this as just a political issue. I look at this as a very severe issue. I think it's probably one of the most severe issues that we have going on in this country, and it affects Christianity. So that's why it's of interest to me. There's this quote here from Lino Groglia, it'd be quote number 3, and he's a Texas law professor and federal appellate court nominee. And he sort of has a great statement here in a Law Review article where he summarizes this predicament that we find ourselves in. Do you mind reading that?
Judicial usurpation of legislative power has become common and so complete that the Supreme Court has become our most powerful and important instrument of government in terms of determining the nature and power of American life. Questions literally of life and death, abortion and capital punishment, of public morality, control of pornography, prayer in the schools and government aid to religious schools, and of the public safety, criminal procedure, and street demonstrations, are all now in the hands of judges under the guise of constitutional law. The fact that the Constitution says nothing of, say, abortion, and indeed explicitly and repeatedly recognizes the capital punishment that the court has come close to prohibiting has made no difference. The result is that the central truth of constitutional law today is that it has nothing to do with the Constitution, except that the words due process or equal protection are almost always used by the judges in stating their conclusions. Not to put too fine a point on it, constitutional law has become a fraud, a cover for a system of government by the majority vote of a 9-person committee of lawyers, unelected and holding office for life.
Doesn't that just about sum it up?
I like this guy.
I like him too. And, you know, this quote goes back to 1985, so it's a little bit dated, but I would say since he said that in 1985, this situation hasn't improved. In fact, it's gotten worse.
Yeah.
And I love what he says, how all of these decisions, abortion, prayer in public school, immigration, it's in the hands of federal judges under the guise of constitutional law. And he basically says constitutional law has become a fraud, a cover for the system of by the majority vote of a 9-person committee of lawyers. I might correct that a little bit. It's actually not even a 9-person vote. It's a 5-person vote because you only need 5 for a majority opinion. Mm-hmm. In fact, there's a famous saying there under quote number 4. I'll just go ahead and read it. It became popular amongst jurists during the Earl Warren era. Mm. And the quote was, with 5 votes, we can do anything. And so he says the reality of the situation is constitutional law has nothing to do with the Constitution, except it's wrapped up, these decisions, in this flowery language like due process and equal protection. And your average person is extremely frustrated with this because their government is out of control. And don't we complain a lot about Christians not wanting to vote, not wanting to get involved in the process? Well, this is probably one of the reasons why they don't get involved. You know, they don't feel like they have a say in anything. So anyway, I thought that quote by Greglia, you know, was really, really helpful. And when you go back to the origins of America, this is not how it was set up. Notice this quote here from David Barton, whose books I recommend to folks. It's quote number 5. Do you mind reading that to us?
Sure, and I don't see that on this stack right here. As in many documents, the Constitution lists the most important aspects first, progressing to those of lesser consequence. Following the preamble, Article 1 describes the Congress, Article 2 the presidency, and Article 3 the judiciary. Not only does the order of listing reveal the relative position of importance, the amount of detail provided by each branch also reflects its relative importance. The legislature, Article 1, received 255 lines of print, while the presidency, Article 2, required only 114 lines. The judiciary, Article 3, merited a mere 44 lines.
So you'll notice with our Constitution that the branch of government that they were afraid of most, our founding fathers, was the legislative branch. So they listed that first and gave it the most detail to hem in its powers. Then they were afraid of an all-powerful president, and so they listed that second, and the amount of detail for the president shrunk some. And then you notice Article 3, which governs the judiciary, is mentioned last, and it has the fewest amount of lines. So if George Washington, Thomas Jefferson, Madison, Hamilton, John Jay, all those guys could be resurrected from the dead and transported back to America in the year 2017 and watch a district court and a circuit court knock down a executive order to defend America's borders, I think they would just be stunned. I mean, it might be harmful to their health if they had to see that right away. Probably traumatize them and send them right back into right back into the grave. But you know, you can see very clearly that never was the judiciary given the power that it wields today. And in fact, Federalist Paper number 78. Now, most people don't even know what the Federalist Papers are. You know about the Federalist Papers.
And weren't they written for a New York farmer?
It's exactly right. The Federalist Papers were written by Hamilton, Madison, and Jay, to convince the state of New York to ratify the Constitution. And people say, well, you know, you got to be a scholar to read the Federalist Papers. But as you pointed out, they were written for the farmer. They were written for somebody at that time that had about an 8th grade education. So it shows you how dumbed down, you know, we've become, where we look at that material from back then as so lofty and scholarly. But the Federalist Papers therefore become a huge source of light to us in terms of the original intention, you know, of the Constitution. And if folks get a copy of the Federalist Papers, and they even have a Federalist Papers in plain language, if some of the Old English is troubling to people, you know, kind of like the NIV version, you know, of the Federalist Papers. But Alexander Hamilton, one of the authors of the Federalist Papers, in Federalist number 78, called the judicial branch of government the least dangerous branch of government. So what he said was, don't worry about the judiciary. It doesn't really have a lot of power anyway. And that's why they weren't afraid to appoint federal judges, you know, for life. And so everything's been sort of tipped on its head. You know, I mean, over time, the judicial branch of government, the least dangerous branch, has actually become the most dangerous branch of government. And they wield this tremendous power where they can overrule the will of the people and other branches of government over and over again with no textual support at all. And they do it from their life tenured position. Being an appointed judge, you know, they don't stand for election. And, you know, I get the whole idea of judges. I mean, I was raised in the home of a judge. My dad was appointed to the California bench by George Duke Majan. And I remember my dad, people would say to him, well, do you like your job? Do you want to keep your job? And he would always say, well, that depends on the voters. Because at the state level, the voters have to vote you in or not.
Retain you.
Retain you, that's a better expression. And so he lived his life in that position. He was in that position for a number of years, but he didn't act like a god. He always understood that he was under the authority of the people. And if you read some of my father's decisions, you know, I was working at a legal newspaper at the time, and they didn't know that Fred Woods was my father, so I could hear him, the liberals there, complaining about him, you know. And one of the things they complained about is Justice Woods keeps citing the transcript from the court case, because he was an appellate court judge. And he keeps citing the transcript. And I'm thinking to myself, well, of course he's citing the transcript because he understands that he's not there to make law. He's there to follow the law. So he had no desire to make things up. And he always understood that he was there by the voice of the people. Now, you compare that to this nonsense going on today where these judges at the federal level don't stand accountable to the people at all, and frankly, they could care less about the textual support for their decisions. And it has all the earmarkings, you know, of what I would call soft tyranny. That's what we're living in now, a form of soft tyranny. I think it was Mark Levin who calls it a post-constitutional republic.
Yes.
That's sort of, is that your take on it?
I agree.
Took the words right out of your mouth.
I don't bloviate.
Yeah.
I agree.
Yeah. So I wrote an article on this on my Word on Politics blog, and now I'm getting to the how do we fix it, because we could all gripe until the cows come home. What do we do about it is really the question. And I'm kind of a solutions guy. You know, sometimes we spend so much time describing the problem, you know, that we don't get to the solution. But there actually is a solution to some of these things.
Well, I was going to say, from your basketball, you had an offense, and then you had a defense, right? Mm-hmm. So you executed the play. Mm-hmm. Okay.
Yeah.
Let's execute the
play. Let's execute the play. One possible solution is impeachment. Okay. So do you have quote number 7 there?
Yes.
This is taken from our Constitution, but it's sort of wrapped up in a quote from my own blog piece. So go ahead and read number 7 if you don't mind.
The power to impeach federal judges is expressed in Article 3, Section 1 of the United States Constitution, which governs the federal judiciary. The judges, and this is a quote, the judges both of the Supreme and inferior courts shall hold their offices during good behavior, end quote. Judicial bad behavior would obviously encompass refusing to follow the Constitution and the laws of the land. However, as evidenced by the failed attempt to remove former President Bill Clinton from office for perjury and obstruction of justice, the American people seem to have little patience with the impeachment process, thereby making it a politically unviable option today.
So one solution is impeachment, because it says in Article 3, remember, which governs the judiciary, the judges, both of the Supreme and inferior courts, shall hold their offices during good behavior. Now, what's bad behavior? To me, it's not following the Constitution. That would be bad behavior. So they become impeachable at that point. The problem with that is we tried that with one of our presidents, Bill Clinton, and he was impeached by the House, and the Senate never. So the way it works is the House impeaches, the Senate removes. Okay, so he was impeached by the House, but the Senate didn't have the intestinal fortitude, even though it was controlled by the Republican Party at the time, to remove him from office because they discovered it was politically unpopular to do that. So impeachment has been sort of pushed aside as a result, and it's not really looked at as a viable option. Another solution is you wait on the President of the United States, who in this case is Donald Trump, to appoint constitutionalists to the bench. Mm-hmm. Now, how do I feel about that? I guess the terminology I would use is mixed feelings. I have a lot of optimism in this regard because of his latest pick, Gorsuch. But at the same time, I've been down this road before. For example, do you know who authored the Roe versus Wade decision?
I should.
Harry Blackmun.
Okay.
Do you know who appointed Harry Blackmun? Richard Nixon.
Okay.
Okay. Do you know who authored the latest decision about same-sex marriage, the Obergefell decision, a guy named Anthony Kennedy? Do you know who appointed Anthony Kennedy?
Bush 41, right?
It was our political hero, Ronald Reagan.
Oh, it was Reagan.
Appointed Kennedy. One of our most conservative guys. Do you know a justice named David Souter, who wrote a horrible decision called the Kelo decision, which chipped away at private property rights, Fifth Amendment rights? And who appointed David Souter? It was Bush 41. Okay. And then we have the upholding of Obamacare by Chief Justice Roberts. Do you know who appointed Roberts?
Bush 43.
Yeah, Bush the second, Bush 43. So what I'm saying is, with Republicans, you can get some good guys in there, like Thomas and Scalia, but it's a very mixed bag. You also run the risk of getting some lousy people in there. And just because they have an R in front of their name for Republican doesn't mean they're going to turn out to be a good jurist. So that option of waiting on Trump to, just appoint some conservatives, is sort of a, you're going to get a mixed result with that, if history is any guarantee. I'd much rather have Trump appointing these people than Hillary. But with Hillary, you've got about a 0% chance of getting anybody good. With a Republican, you've got about, if history is any guide, about a 1 in 2 chance. So that option is good, and that was the only option I knew for a long time. But then I had a chance to have lunch with Tom DeLay, who was the former Speaker of the House. Yeah, you can hold that book up. Who wrote this book here called Revival, Revolution, and Rebirth. And he asked me, point blank, how do we fix the judiciary? And I said, well, we've got to wait on the president to give us some conservative picks. And he looked at me right in the eye and said, wrong. There's another option here. And you need to read Article 3. In Chapter 20 of this book that was just held up by Tom DeLay and Wallace Henley, in Chapter 20 he gets into what Article 3 actually says. Article 3, which governs the judiciary, places the power to rein the judiciary in the hands of the United States Congress which happens to be controlled by the Republican Party at this time. So the Republicans have the Senate, they have the House, they have the presidency, and so they don't have an excuse for not doing this, in my opinion. What do you think?
I would agree. We gave them, those two branches.
So let's get some results, huh? Is
Yes.
that too much to expect? So what can the judicial branch of government do? Well, do you have there quote number 8? And this is a citation, some of my words, but the important part is Section 1 of Article 3. Notice what it says there with quote number 8.
First, according to Section 1 of Article 3, other than the Supreme Court, Congress is responsible for creating all other federal courts. Quote, the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish, end quote. Such power of creation also includes the authority of Congress over the wayward Ninth Circuit. According to DeLay and Henley, quote, this also means that what Congress can create, it can uncreate. Thus, Congress should now move aggressively in the direction of dissolving the Ninth Circuit, or dramatically cutting or even eliminating its budget, or perhaps breaking it up into something less monolithic.
So look at this language. I mean, how many people know this is in here? The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the what? Congress may from time to time ordain and establish. There wasn't even always 9 people on the United States Supreme Court. The expansion of the number was a congressional decision. And beyond that, the inferior courts, which would include the circuit court and the district court, exist because Congress put them in existence. And what they can create, they can uncreate. Anytime the Republicans want to do it, they can dissolve the Ninth Circuit. My dad used to call the Ninth Circuit the Ninth Circus because it was known for doing insane things like declaring the Pledge of Allegiance unconstitutional. What insanity is that? And at some point, I want some of these people that I vote for over and over again to grow a spine and to start exercising the power that they have under the Constitution, and to either shrink the number of jurists on the Supreme Court, shrink their budget, shrink their power, or something to that extent. It's all there for them to do. It's just a matter of having the will to do it. So that would be a much more viable solution, don't you think? Now there's something else. Can you read quote number 9 there?
Yes. Second, according to Section 2 of Article 3, Congress has the authority to limit the jurisdiction of the federal courts. Quote, the Supreme Court shall have appellate jurisdiction both as to law and fact, with such exceptions and under such regulations as the Congress shall make, end quote. Simply put, this means the Congress has the ability to tell the federal courts what types of cases it can hear or cannot hear. Thus, Congress should also immediately move aggressively in the direction of passing legislation that removes from the federal judiciary the ability to hear cases involving any and all hot-button cultural issues. This would include removing from the federal judiciary cases involving the so-called separation between church and state, abortion on demand, universal health care, and also immigration.
See, look at this language. This is also in Article 3, which governs the judiciary. The Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions under such regulations as the Congress shall make. In other words, the ability to determine what cases the federal courts can hear rests with the power of the Congress. So you know what they could do in a nanosecond? They could say, guess what? We're shrinking your jurisdiction. You're not going to rule anymore on abortion. You're not going to rule anymore on the 10 Commandments and the schoolhouse wall. You're not going to rule anymore on immigration. I mean, we're not some kind of battered spouse that has to just put up with this. The power to change is all there in the language of the Constitution, and that I'm a lawyer, and I knew very little about this until Tom DeLay, brought it to my attention, and it's all there in Article 3. This is not secret mystical knowledge. It's a power that our founders gave us because they foresaw that such a day might arise that we're in now. Isn't it amazing how much foresight our founding fathers had, where they could foresee all of these problems? But go ahead.
I think it's because they were so well versed in history that they knew the nature of mankind.
Amen. Amen. They believed in good old-fashioned depravity.
Yes.
And power corrupts. Absolute power corrupts, absolutely.
Yes. And sin.
And sin, wow. Don't say that too loud. Now, there's something else that they can do, and this takes us to quote number 10. Can you read that for us?
Yes. Third, Article 3 fails to assign to the federal judiciary any enforcement power. In other words, when the federal judiciary issues a decision, it is completely dependent upon the executive and legislative branches of government to enforce their decisions. DeLay and Henley note, quote, rulings by SCOTUS or other federal courts, therefore, are only opinions if not enforced by the executive or legislative branches or the states, end quote. Thus, when the federal judiciary makes decisions that have no basis in the actual text of the Constitution, the other branches of government should simply refuse to enforce such decisions. It is within both the authority and duties of the alternate branches of government to do so, since its members also take an oath to uphold the United States Constitution. In other words, the other branches of government should follow the example set by President Andrew Jackson. Jackson is alleged to have once quipped in response to judicial overreach by then SCOTUS Chief Justice Marshall, quote, John Marshall has made his decision, now let him enforce it, end quote. Such constitutional discernment and inaction on the part of the other coordinate branches of government would render the federal judiciary impotent and would have likely led to victory in the culture war long ago.
See, the bottom line is Article 3 doesn't have an enforcement power. A judge can't enforce his decision. He's dependent upon the executive branch and the legislative branch for that. So what can the other branches of government do when they get some outrageous decision that has no basis in the Constitution? They should just sit on their hands and do nothing with it and let it stay an opinion and don't enforce it.
Didn't we just see that in the previous administration with Holder and the president, that they decided they weren't going to enforce certain things?
Right. And they did it, I think, wrongly because they were following
Defense of Marriage Act.
Defense of Marriage Act, but we could do it related to abortion because there's nothing in the Constitution that supports abortion. You know what should have happened in 1963? Now, I realize hindsight's 20/20, but when the Supreme Court came in and threw Christianity out of the public schools, everybody just should have said, you know what, that decision is a lawless decision, and we're going to ignore it. And there's actually precedent for this because that's what Andrew Jackson said concerning John Marshall in a case of judicial overreach. John Marshall being the Chief Justice at that time. Jackson said John Marshall made his decision. Now let him enforce it.
Yep.
And so this power to not enforce decisions that have no basis in the Constitution is there, if we would just choose to exercise that power. Now, people talk, when you talk like this, people say, well, come on, the Supreme Court is the ultimate arbiter of all constitutional questions. Not so. Do you have that quote from Thomas Jefferson? It's number 11.
Yes. Do you want me to introduce it?
You can just, it's from his writings, the writings of Thomas Jefferson.
All right.
But you can just read the quote.
Quote, you seem to consider judges as the ultimate arbiters of all constitutional questions, a very dangerous doctrine indeed, and one which would place us under the despotism of an oligarchy. Our judges are as honest as other men, and not more so, and their power the more dangerous as they are in office for life, and not responsible as the other functionaries are to the elective control. The Constitution has erected no such single tribunal.
See, Thomas Jefferson himself is arguing here that it's not just the Supreme Court that's the arbiter of constitutional issues. It's all the branches of government. Now, can you read that second quote by Jefferson? I think it's number 12.
Yes, and this is in a writing to Spencer Roane.
Yes.
Each of the three departments has equally the right to decide for itself what is its duty under the Constitution without any regard to what the others may have decided for themselves under a similar question.
See, that's pretty clear, isn't it?
Mm-hmm.
In other words, don't congressmen, don't senators, doesn't the president, don't they take an oath to uphold the Constitution? So if the Supreme Court brings out some ruling that is wildly unconstitutional, I think the other branches of government, if they're going to uphold their constitutional oath, should make a decision to not enforce certain rulings. And it's not wild talk. When you get into the actual history of this country, you'll find citation after citation after citation where our elected representatives at one time in our history understood this. In fact, in this book here by David Barton, which I recommend people read, called Original Intent, on pages 263 to 277, he has so many citations from founders of America who said over and over again that the decision of what's constitutional and not doesn't just rest with one branch of government.
Right.
It rests with all three. In fact, Abraham Lincoln, considered one of our greatest presidents, did this very thing with a decision called the Dred Scott decision. Can you read to us a little bit about that, number 13?
Yes. In the Dred Scott decision, the Supreme Court declared that Congress could not prohibit slavery, and that slaves were only property and not persons eligible to receive any rights of a citizen. Fortunately, the other branches of government ignored the court's ruling. In 1862, President Lincoln did issue the Emancipation Proclamation, which was a direct affront to the court's decision. Mm-hmm. Because President Lincoln was guided by his own understanding of the Constitution, rather than by the judiciary's opinion, he declared freedom for slaves.
So here's Abraham Lincoln. The Dred Scott decision comes down, and the Dred Scott decision says that slaves don't have any constitutional rights, basically what the decision said. So what does Lincoln say? Well, the Supreme Court is the supreme law of the land, and what the Supreme Court has said can't be challenged. No, he does the opposite. He does not accept the ruling. And he issues the Emancipation Proclamation, which freed slaves, directly against the will of the court. So, people might listen to us talking about this and think we're doing crazy talk, but the way you and I believe about this fits exactly with the history and traditions, of the United States of America. The ability to say no to a Supreme Court decision is a power that the other branches of government have. It's just as real as impeachment. It's just as real as shrinking their jurisdiction. Mm-hmm. It's just as real as dissolving the Ninth Circuit when it becomes the Ninth Circus. Those powers are all there, and yet for whatever reason, they just lie dormant and unused. So we don't have to be this battered woman. We have the ability to fight back. Now people say, well, wait a minute, isn't the Supreme Court ruling the supreme law of the land? And there isn't a shred of evidence in the Constitution that tells us that. The only thing about the supreme law of the land is found in Article 6, Clause 2. Can you read that real quick? That's quote number 14.
Incidentally, nowhere in the Constitution is the court given supreme authority over the other two branches. The Constitution itself, instead, was declared to be supreme, not the will of individuals holding federal office tasked with enforcing it. That's Article 6, Clause 2.
What it says is the federal government is the supreme law of the land.
Yeah.
It never says that the Supreme Court is the supreme law of the land. Yet your average person that's viewing this today thinks that because they're told that over and over again. But if they were actually to go back and read the Constitution, which only spans about 11 pages, by the way, including the Bill of Rights, they would discover that there isn't anything in the Constitution that gives the Supreme Court this awesome power that it has. Yeah.
I was going to say, and look, Pastor, you even put it right there for me to read.
Yeah, that's right.
This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land. And the judges in every state shall be bound thereby, in anything in the Constitution or laws of any state to the contrary notwithstanding.
So there it is in black and white.
Yeah.
Now, a lot of people have this view that once the Supreme Court says something, it can't be overturned. The fact of the matter is the Supreme Court has overturned itself over 100 times. I think the last time I checked that number, it's more like 120 times. So people should not have this view that some kind of Supreme Court opinion or judicial opinion, you know, with these judges, they're in their robes, they went to Harvard and Yale. It's like, who are we, Mr. and Mrs. America, to challenge them? The fact of the matter is they can be challenged. They are not demigods, and they have actually overturned themselves over 100 times.
Well, I'm curious how many of those times where the overturn was the bad decision.
That could be true.
Because of
sometimes it's good, sometimes it's bad.
Yeah, because of FDR and his impact on the courts.
Yeah, that's probably. I mean, that's a good point. But what I'm saying is, we shouldn't look at the Supreme Court as Moses from Mount Sinai,
Yes.
etched in stone. And there have been some lousy, with a capital L, Supreme Court decisions. For example, Plessy versus Ferguson, 1896. Separate but equal, that caused racial segregation in America. And they didn't overturn themselves in that case for over 50 years. Korematsu versus the United States, which placed in internment camps Japanese Americans. This one really got under my skin. Zivotofsky v. Carey, where our own Supreme Court couldn't figure out that Jerusalem is the capital of Israel. So, you know, it's not a thing where, you know, we should look at the Supreme Court as if they're some kind of godlike characters and figures. So here are the Republicans. They've got all the branches of government, Senate, House, executive branch, and they have the ability to put a stop to some of these things. Now, why do you think they won't put a stop to it? I have my theory. Do you have a theory on it? Not to put
you said something about intestinal fortitude.
Well, what is the issue? What is the issue that they use over and over again to get us evangelicals to the polls to support their candidates? The Supreme Court.
Yes.
Vote us into power. The Supreme Court.
If they don't fix it, then we will continue, to turn out in numbers.
So if they fix it, they lose a campaign issue. Now, I can't see people's hearts, but for the life of me, I can't understand why we don't step forward under the authority that we have under the Constitution and solve this issue. And I think a lot of times as politicians don't want to solve the issue because they'd rather have the campaign issue. Because if you solve the issue, the campaign issue disappears. You can't create fear in people. Get out and support our candidates or the Supreme Court's going to fall apart. Now, one other thing, and we're getting close to closing here. People talk about the nuclear option. Let me give the ultimate nuclear option. We went through some things the court can do. But did you know that there's something found in Article 5 of the Constitution called the Convention of the States?
Yes.
Can you read that? It's number 16.
Yes.
You know something about this, I guess.
Yes.
Okay. Yeah, I tried to underline the most important part.
Article 5, the Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, or, on the application of the legislatures of 2/3 of the several states, shall call a convention for proposing amendments. which, in either case, shall be valid to all intents and purposes as part of this Constitution when ratified by the legislatures of 3/4 of the several states, or by conventions in 3/4 thereof. As the one or the other mode of ratification may be proposed by the Congress, provided that no amendment which may be made prior to the year 1808 shall in any manner affect the first and fourth clauses in the 9th section of the first article, and that no state without its consent shall be deprived of its equal suffrage in the Senate.
Yeah, the most relevant language here is or on the application of the legislatures, that would be the state governments, right, of the 2/3 of the several states, shall call a convention for proposing amendments. Now, for the longest time, I thought, well, the way you have proposed amendments is they've got to go through the House and the Senate, and 3/4 of the states have to agree to the amendment. That's how we got most of our amendments, if not all of them, passed. But did you notice this little clause here? That if the 2/3 of the states get together, they can pass their own amendments.
Were you going to discuss how this got included? Because there was quite a bit of discussion at the convention.
Well, you may know more about it than me, so feel free to illuminate
this
us.
was a compromise to put this in there because they realized that they were asking Congress, in essence, to bind itself. So you wouldn't get amendments that bind and restrict the power of the federal government coming from the federal government. So that's why we came up with this compromise that, yes, we will include this option and this retain power at the state level to come in this way.
So here we are in the year 2017. Does it look like the federal government's going to police itself? It doesn't look that way, does it?
Yes, that's a more articulate way of saying
yeah,
it.
and so our founders understood that this day would arise, and they said the states. Now, there's a bit of a hurdle because you've got to get, if I'm reading this right, 2/3 to agree. I don't know how close we
2/3 to
are.
call a convention, and then 3/4 of the legislatures have to ratify
to get the amendments through. Okay,
Yeah.
but there's a tool in place whereby the state governments have said we've had enough, and we're going to rein you in. If you won't go on a diet, we're going to make you go on a diet. And they have the power to pass amendments such as wild Supreme Court opinions can be overturned. So if these suggestions by Tom DeLay that we read about in Article 3 remain unused, the ultimate option still remains in Article 5, which is the Convention of the States. And this is what Mr. and Mrs. America need to understand. We are not helpless victims in this form of soft tyranny that we're in. There are powers. You know, Paul the Apostle used his legal authority as a Roman citizen, we read about it in the book of Acts, to preach the gospel.
Right.
Now, why wouldn't we as Christians not follow that same vein and use the legal power that we have, just that we've discussed in the last hour, to expand to expand God's purposes in this country and to get control of a government, that's out of control. So now, he may not like me using his name, but Rick Miller, who we both know, who's our Texas rep, he's the guy that really talked me into this Convention of the States, because I at first was sort of, kind of reluctant about the whole thing. So he's on board with it. From what I understand, our home state resident state of Texas is on board. I don't know how close we are to the 2/3 point, but the power is there to change things if we would just get the will. That's what I'm trying to get at, the will to use it.
I'm like you. I don't know the numbers, but it is a very strong movement.
Yeah.
And so this is not something that right now is untenable. It's a strong movement. Yes, Governor Abbott has come out strongly for this, and so has our House District 26 legislator Rick Miller, and even a famous author has written a book about prospective amendments.
Yeah.
So it's
Well, I was going to bring that
building.
up. Well, I was going to recommend resources for people to read. So I would recommend, I think it's who you alluded to, Mark Levin's book
Yes.
called The Liberty Amendments, where he explains what Article 5 is, what the Convention of the States is, and here are some amendments that could be proposed to rein in an out-of-control judiciary. I would also recommend this book here by a friend of ours, Jenna Ellis, who's a constitutional attorney in the state of Colorado. Her book is called The Legal Basis for a Moral Constitution, and she's a practicing lawyer in Colorado, and she's a professor at Colorado Christian University.
Okay.
And so it's a wonderful book she's written, but towards the end she pushes the reader, in the direction of this Convention of the States. Her stuff is available on Amazon. Mark Levin's stuff is available. So you can't fight a war unless you have intellectual ammunition. And so God is raising up, some good people like Mark Levin and Jenna and others, to talk about this Convention of the States. So we've done, and my book, which is more of a complaining book than a solution book, it's called Darwin, Evolution, and the American Constitution, sort of tells us how we got to this point. And how do we get to this point where judges just make decisions independent of the text of the Constitution? Well, they got involved with the theory of evolution a long time ago, where if man is evolving upward, then you need a constitution that evolves upward. So who's going to evolve it upward? The judges say, I'll do that. So a lot of this is evolutionary in thinking, and I wanted to write a book on this because most people don't connect the dots.
Right.
But I think Amazon has these if you're interested, or you could send us an email here at the church and we could get you this one at least. The other ones, the Barton book, the Jenna Ellis book, and the Tom DeLay book. You'll probably have to get on Amazon and so forth. So judicial tyranny, which is what we're in, we've tried to describe that. How do we fix it? I've given some solutions from Article 3 that the Congress could do today. If that doesn't work, we have another solution in Article 5 that the states can implement. And I hope this gives the viewers hope to not make them feel like we're just powerless in this whole thing. We are edging into a judicial form of soft tyranny, but it's fixable. One of the things the devil wants to do is to keep us ignorant. If we're ignorant, we don't know how to fight back. And hopefully a presentation like this will educate people in terms of how to fight back. But I don't know, do you have any concluding thoughts, comments, questions? Altar call?
Yeah. No, I'm doing pretty good right now. I think, restraining myself and not
taking over.
Yes,
Well, we'll let you take over next week.
Tomalea's show on the internet. So
yeah, we do have a few questions. One person writes in, it's obvious we might as well dissolve Congress and the executive branch and just allow the judges to rule. What is the political word for this type of government?
oligarchy.
Yeah, I think oligarchy is what we're in now. I don't think we're in favor of dissolving the executive and judicial branch. We want the executive and judicial branch to function like they're supposed to and to hold the out-of-control branch in check. One person writes, since I live in ultra-liberal left coast Washington, I can't call or write my congressman, then what should I do other than prayer? Another person says, same here. I live on the conservative east side of the state. What would your advice be to someone in that predicament?
To start looking at the committees, because we have Judiciary Committee within Congress. Mm-hmm. And so you are not constrained to only contact your congressman. You can contact the members of those committees. And generally what you have to do is look through the website for Congress, for the House, to find the roster and the contact information, but you have a right to go to those committees and lobby them. And nowadays it's as simple as clicking on the web page on contact, and then you put it right in writing and send it off to them.
And you know, when the communists or the socialists are not in the majority, they don't sit around and complain that we're not in the majority. They put themselves into positions of influence.
Yes.
And I bring that up because you mentioned the committees. And I wish we as conservative evangelicals had more of that of a mindset, that we want to get on the committees, we want to get into the law schools, we want to write the law review articles, and we need to start thinking differently if we're going to really impact the culture for Christ. I know you've got to go. One person writes in, the majority of our citizens, the USA, are even unable to understand this. I think if they understood it, it would be different. So we have, dumbed down things through propaganda where your average person maybe has never even read the Constitution. So the first order of business is to arm yourself with education. That's why we mentioned some of the resources, that are helpful. And one person says, thank you. I appreciate the work you put forth into this. Very well done. We appreciate it. Well, we're going to wrap up. Tomalea, thank you for being with us.
Okay.
And I hope this was semi-enjoyable for you.
It was.
Okay, good. We roped her into service at the last minute, and we just want to say we love everybody, and we hope you'll be with us next time. Now, next week, we're not going to be having this because I'm going to be traveling at the Stealing the Mind conference, and I'll put on this website or Facebook page and others the way you can stream that conference for free, because it's a worldview conference.
Oh, good.
So it deals with the same kind of issues we've been talking about for the last hour. So that'll be available. And then I will see you all in March. So God bless you, and thanks for watching.